Jai Hind, friends. I hope you're studying well and swiftly moving forward with your preparation towards the civil services exam. In continuation of the previous discussions, we will take 10 more questions today to learn some more dimensions of polity. Those of you who are directly and only watching this video may like to pause after seeing the question, attempt it, and then proceed to hear the brief explanation. Or attempt the question first on WhatsApp and Telegram channels and then learn more from these videos. Like always, we will also learn something more than the question on the screen through images. And in this video, we continue the images from the Constitution of India that were designed and illustrated by Sri Nandlal Bose. You would remember in the last video the images for the first 10 parts of the Constitution, and we will see 10 more in this video with every question. That way, we would be able to see the images in the 20 parts of the Constitution. Let's take question number 511. Which of the following powers of the Prime Minister of India are not provided for explicitly in the Constitution of India? To advise the President regarding appointment of ministers, allocation of business, rank of ministers, and summoning a meeting. Now, in this case, it is Article 75 which comes in the picture, which very clearly says that the Prime Minister shall be appointed by the President and the other ministers shall be appointed by the President on the advice of the Prime Minister. As you can see here, the first option is definitely correct here. Then, allocation of business among the ministers is an inherent responsibility understood as a necessary action. Associated with that itself is the designation of the ministers. All this is internal to the Council of Ministers, and the ruling party or the parties, they decide under the formal leadership of the Prime Minister. So, which is not provided in the Constitution? 2, 3, and 4. So that's the correct answer. Next question is regarding the provisions concerning the powers of the Supreme Court, how that can be amended. But first, the image on the top right is part 12 of the Constitution with the image of Natraj, the deity of dance, and Rodra Ras. The left back hand is holding fire, the right hand is in Abhay Mudra, and Natraj is balancing on top of a dwarf named Apasmar, who signifies ignorance and unawareness. Let us see the question now. So, to amend the provisions regarding the powers of the Supreme Court, of course, it will need a constitutional amendment bill under Article 368. And since we have unified judiciary in India, affecting provisions of Supreme Court would also affect the states in our federal setup. So we can easily guess, and logically, that is the reason why in Article 368, there is a provision specifically for this matter where it says that if such amendments make any changes in Chapter 4 of Part 5, which is basically the Supreme Court, then it will require ratification by the legislatures of not less than half of the states. So, that is why for this matter, the correct answer should be C, where it says a constitutional amendment passed by the parliament and ratified by at least 50% of the state legislature. So the correct answer here should be C. Then the next question about the powers of the governor to appoint which of the following. Now, first option, judges of the High Court. Now, judges of the High Court, very much like the Supreme Court, they're appointed by the president, not by the governor. So, first option is wrong. Then, State Finance Commission, yes, they are appointed by the governor. And provision for that is in Article 243I. Regarding municipalities, and the purpose of this State Finance Commission is distribution of taxes between the states and the panchayats as well as the municipalities. So definitely the second option is correct option. Then third says Accountant General. Accountant General is a post under the Comptroller and Auditor General of India. So their appointment is actually done by the CAG itself. It is another post, which is the Advocate General, the law officer of the state. That Advocate General is appointed by the governor, not the Accountant General. So here the only correct option is the second one, members of the State Finance Commission. Moving on, question number 514. Local self-government in India can be best explained as an exercise of. Some options are given. Now, in India, local self-government is not a case of federalism because the division of power, it is not done by the constitution for the local bodies the way it is done for center and state. It is not done for the local self government. So, for example, for center state division of power, we know there is the seventh schedule. Similarly, there is a schedule for local self government in Schedule 11 and Schedule 12 for panchayats and municipalities, respectively. But those subjects are not automatically devolved by the constitution. Which powers the local government will have depends on the state legislation. It is also not a case of administrative delegation, which basically means a superior administrative authority delegating its authority to a lower authority. In such delegations, the superior authority retains the complete responsibility. Our local government is envisaged to be a responsible government in its own right. Then the question's true answer is more of the spirit of democratic decentralization, where the source of authority of the local self-government, it lies in the law, with shift of accountability as well. The local government will be accountable for whatever works they do. So correct answer looks like C, we have found, but let's look at option D, which says direct democracy. Now, definitely there are some aspects of direct democracy in our local government. For example, the idea of the Gram Sabha in the panchayats, where all the adult members of the villages, the voters, are members and take decisions on the matters. However, this concept exists only for panchayats, and there is no such provision idea in the urban local government. The closest equivalent in the urban local government is an area sabha, where again all the adult members of the urban area are made member, but this is there only in some of the states, and it is not a requirement in the constitution. So anyway, the correct answer here should be C. Democratic decentralization, a large number, 80%. It's a decent, satisfactory level of performance to my mind. Then next question, 515. Here, first statement: the National Commission for Minorities is not a constitutional body. That is a correct statement. National Commission for Minorities was created by the National Commission for Minorities Act of 1992. And then it says the term minority is not defined in the Constitution of India. That is also correct. We know Articles 29 and 30 of the Constitution, they mention the term minorities, but they do not define who is a minority. It only mentioned two types of minorities: religious minorities and linguistic minorities. But it does not define as to which religious group would be a minority or which linguistic group will be a minority. In fact, minority is not defined even in the Act. If you see here in the Act, the definition that is given for the minorities, it says minority means a community notified as such by the central government. So that is simply saying that whoever the central government declares or notifies as a minority, they are a minority. Now that's not really a definition. So it is the Supreme Court which gave a definition in the very famous TMA Pai case, TMA Pai versus the state of Karnataka in the year 2002. So, and it said that a community which is numerically less than half of the population, less than 50% of the population, they should be considered as a minority. That's just a guideline. Anyway, both these statements are correct, which were given in the question, right? So both are correct options here. Next question is which of the following most suitably signifies the role of Supreme Court of India as a guardian of the Constitution of India? Now, guardian of the Constitution, that is to say a guard, okay? As in it will stop anyone from attacking the Constitution, or more simply, to stop from violation of the Constitution. It will stop. So if you see option 1, it says independence from the executive and the legislature. Now, that is definitely required for judiciary to actually work like a guardian. However, independence itself does not mean that they have become a guardian. This is required, but that's like not really directly resulting into their role. So what they do with this independence, that is what is more important. Similarly, second option says power of judicial review, wherein the court can examine a legislative, executive, or even a judicial action for the violation of constitution and its principles. This precisely is the work of a guardian. So we have got our answer, but still, let us see the other two options as well. Where the third one says final interpreter of the constitution. This role is also very critical for finality of understanding when different interpretations may be contested. It may also be in the picture when the court is guarding against violation of the constitution. But this role is more of an arbitrator's role. Finally, the fourth option, writ jurisdiction. This is a power which is, in a way, one of the sources of judicial review. However, the purpose of writ is to protect legal rights, which sometimes maybe indirectly guards the constitution also. But that's not really the main purpose behind all of it. So the most suitable choice, as the question demands, would be option B here, power of judicial review. In the next question, the proportional representation system of election as an electoral method, it ensures which of the following. Now, the proportional representation system of election for representation of people ensures the electoral strength of a party matches with their political strength in the legislature. So, if a party has received 1% votes, it would mean they also get 1% of the seats. For example, in our Lok Sabha, that will be around 5 to 6 seats. Therefore, it ensures even small groups, that is minorities, get a voice proportionate to their population. Now, rule of majority, second option here. It is a type of democratic system. Proportional representation, if combined with such rules for formation of government, will lead to a rule of majority. But on its own, PRS is only a method of election. And on the same line of reasoning, proportional representation system does not guarantee any stability, as there may not be majority achieved by any party. In fact, this is a major negative of this system for a country like India. To illustrate that, out of the 18 Lok Sabha elections held so far in India, not even once, zero, not even once any party has secured more than 50% vote share. The best was 49%, little more than that, in the 1984 elections. 1984 elections. Yet, 9 out of these 18 Lok Sabhas, 9 out of 18 times, 50%, a single party has got majority. Right? That means 9 other times we have got hung parliament. 9 times single party majority, 9 times hung parliament. That is to say, only 9 out of 18 times, right, there was clear majority. So had it been proportional representation system in our country, it means what? 18 out of 18 times. Since no party got more than 50% votes, 18 out of 18 times it would be a hung parliament. So rather, this is a negative that, there are lesser chances of securing stability in a diverse population like India. Last option, common national agenda, cannot be ensured by any election system, especially in a diverse country and a democracy like India. If you think about it, it is national integration and a common goal or common threat that can drive this kind of a common national agenda in a country, and not how really we conduct election. So the correct answer here is option A. Then the next question is asking about the communities that have been notified by the government as a minority community. This is a further extension of the previous question about minorities. So as of today, there are 6 communities notified as minority. So Muslims, Christians, Sikh, Buddhist, Parsis, and Jains. So 3 out of these 6 which are notified are mentioned in the option. So all of them are there, and various other communities are also there in our country who are not given this recognition, such as the Jews or even the Baha'is, the followers of the Baha'i faith. These are often, Baha'is especially, the world's youngest monotheistic religion, but they are not given this recognition in our country. Then 519. Which of the following is not an essential element of a federal form of government? Now, in this written constitution, division of power, independent judiciary, separation of powers, this is a decently straightforward question, though only one third roughly got it correct. See, separation of power, it may or may not exist in a federal system. However, the other three options, they are essential to define a federal system, along with two more factors, that is the supremacy of the constitution and rigidity of the constitution. These are considered the five core principles. Let's understand, federalism as a core idea. So, at the core of everything is division of power between the different levels of government, that is center and state. To ensure that this is maintained and not destroyed by either parties, the provisions need to be written. So that becomes the second important aspect, division of power. Written provision have to be there. And that written provision should also be the supreme law. And that supreme law should be rigid. That is, they cannot be changed unilaterally by the center. And states' agreement would also be needed. Finally, an independent judiciary is a must to uphold the division of powers and resolve any disputes that may arise between center and states. These are the five logically related characteristics of a federal constitution, and also a natural corollary to have a house of states, that is the council of states or something like the senate, right? There has to be a representation of the states in the central legislature so that the state views can be taken during lawmaking. So the correct answer here should be D, where separation of power is not essential, other three are essential. Now, last question in this video. The term public interest litigation can be traced to which of the following countries? The concept of PIL, it originated in the United States and often considered to have emerged with the celebrated campaign that resulted in the decision of this case, Brown versus the Board of Education in 1954. The social justice and the civil rights movements of the 1960s in the USA saw lawyers using the courts as a tool to challenge racial discrimination. Now, that served as an inspiration for Justices P. N. Bhagwati, who's considered a stalwart behind PIL, and also Justice V. R. Krishna Iyer in the late 1970s, who adapted the idea of PIL in India for the protection of human rights. And this case, Husainara Khatun versus the state of Bihar in 1979. This case is considered the first PIL case in India focusing on the inhuman conditions of under trial prisoners. So the correct answer is USA. Now, that is all for this video. Take care and keep working hard. All the best.